Hello, everyone. My name is Ann Cleveland, and I am a paralegal here at Lyles Parker. Thank you so much for joining us for this new webinar series with the Home Care Association of Louisiana. To get us started today, we have Dr. Warren Hebert.
Thank you, Ann, and thanks to Lyles Parker for agreeing to have the Home Care Association of Louisiana's members and friends to join Lyles Parker's clients who hail from Hawaii, Alabama, North Carolina, Georgia, Florida, Virginia, Pennsylvania, and New York. A warm Louisiana bienvenue to you all. Thanks for being with us. Two of my daughters followed me into nursing. One is a family nurse practitioner who makes palliative care visits in the home. She once told me, "Dad, we are with patients and their families at the most vulnerable, fragile moments of their lives, and often at the end of a life." That's the work that each of you do. And if you're not out making visits, you're supporting those who are in the home doing home health, hospice, and palliative care every day across the nation. Thank you for what you do. Thanks for being here. And again, thanks to Lyles Parker's team and Robert Lyles, Lester Johnson, and Gunnar Jurgensen for doing this presentation for us. We're all looking forward to it. Thank you.
Thank you so much, Dr. Hebert. Dr. Warren Hebert, RN, made his first home health nursing visit in 1985 and has been CEO of the Home Care Association of Louisiana since 1998. An assistant professor of nursing for 4 years at Loyola School of Nursing in New Orleans, Warren is now an adjunct there and at the Rutgers Institute for Health, Healthcare Policy, and Aging Research. Dr. Hebert is on the expert panel on aging of the American Academy of Nursing. Today's webinar is entitled Overview of Civil and Criminal Cases Brought Against Home Health and Hospice Agencies. Our presenters are Robert W. Lyles, Lester Johnson, and Gunnar Jurgensen. Robert Lyles is the current managing partner at Lyles Parker. In addition to a law degree, Mr. Lyles holds both an MBA and an MS in healthcare administration. Robert has worked on the provider side as a federal prosecutor and now represents home health, hospice, and other healthcare providers around the country in connection with Medicare, Medicaid, private payer audits, and False Claims Act cases. While working as a federal prosecutor in Houston, Robert was asked to serve as the country's first national healthcare fraud coordinator for the Executive Office for U.S. Attorneys in Washington, D.C. In this capacity, he advised federal prosecutors around the country regarding healthcare fraud statutes, schemes, investigative tools, privacy concerns, and compliance issues. Les Johnson is a longtime partner at Lyles Parker and is the supervising attorney for the firm's Baton Rouge office. In addition to a law degree, Les holds an LLM in regulatory, transactional, and corporate health law. Les is a Louisiana native as well. Early in his career, he clerked for 2 years for the Louisiana Supreme Court. He is well known in both the provider and health law communities and has represented home health and hospice agencies for almost 2 decades. Core areas of Les's practice include handling Medicare and Medicaid appeals and Medicare and Medicaid participation and compliance. Gunnar Jurgensen, JD, CPC, is a graduate of William and Mary Law School. He represents both home health and hospice providers around the country, mostly in connection with administrative audits. If you have any questions throughout the presentation today, please feel free to type them in the chat box and we will address as many as possible at the end of the presentation. And without further ado, I present your speakers, Robert Lyles, Les Johnson, and Gunnar Jurgensen.
Thank you very much, Ann. Good afternoon, everybody. I'm glad to be here with my colleagues, Lester and Gunnar. Let's go to the next slide. And today we're going to be talking about the enforcement actions that are out there. And I just kind of like to set the stage for the folks that we have on the phone. I know we have folks on the phone today from around the country, but focusing on Louisiana and Mississippi, it's important to understand that the government is taking enforcement very, very seriously. And in fact, they have a Gulf Coast strike force that works out of Baton Rouge, New Orleans, and Gulfport. And there's also a national strike force looking at the COVID-19 fraud cases. And a number of those cases, a number of those investigations are also in Louisiana. So these strike forces, of course, are made up of members of the U.S. Attorney's Office, the FBI, the DEA, and many times folks from the state Mafuku, the Medicaid Fraud Control Unit. The first time I heard that, I thought somebody was disrespecting my mother. But these organizations, they've really kind of gotten to the point where they're very good at cohesively putting together these teams to conduct these Medicare, Medicaid, and private payer audits. And unfortunately, home health and hospice are some of their primary targets when it comes to these cases that we're talking about. And one of the things that you have to understand is, even though we live in the time of post-COVID, and it's my understanding, of course, the president says he's going to lift the national health emergency in May, but the fact is that even though that was the case, if you look at the numbers, the government hadn't been slowing down that much. We had a drop when it comes to a recovery, civil recoveries. There was a drop in 2020, but then in 2021, it more than doubled. We don't have the numbers out yet for 2022, but we expect those to be significant as well. So the government has not been sitting idly by while COVID has been ravaging through the country. There are a number of civil healthcare fraud investigations that have been filed against home health, hospice, and personal care agencies. Number of criminal cases, the number of exclusions is continuing to go up. During 2021, almost 2,000 people were excluded just by OIG. Now you have to understand that's only on the OIG list. When you start adding in all the additional exclusions at the state level, it's a significant number. And that's important for the folks on this call because, of course, if you're taking any kind of federal health benefit program work, you cannot employ someone who has been excluded from participation in federal health benefit programs. Next slide. Now, we're going to start out to begin with. We're going to really kind of, if you were to break this up, we're going to talk about three silos, if you will. The first silo, of course, is we're going to talk about the administrative audits that are going on out there involving home health and hospice. The second silo is we're going to discuss the False Claims Act and new developments in the use of the False Claims Act and how the government is investigating those in the home health and hospice cases. And then third, we're going to discuss the criminal prosecutions that have been taking place involving home health and hospice and personal care providers. Now, when it comes to administrative audits, and it's really almost not even fair to say this or to limit it to administrative audits because a number of civil and criminal cases ultimately are bootstrapped off of what began as an administrative audit. It's important to remember that, okay? It's not like the old days where if you got an audit request in from an old ZPIC, chances are that you could respond to that ZPIC audit. You didn't have to go to bed at night worrying about whether or not the ZPIC was going to make a referral. Occasionally they did. But the UPICs, the Unified Program Integrity Contractors, are much more aggressive when it comes to making referrals over to OIG and to CMS or the MAC and to DOJ if they find evidence of any wrongdoing. So where are they getting their audits from? How are these things being ginned up, if you will? One thing to kind of keep in mind, we live in a time that, and I tell this to my kids, there are no more secrets. The fact is, there is so much data out there that the government can take your claims and they can slice and dice those claims so many different ways to identify outliers. And in fact, if you actually look at the Medicare Program Integrity Manual, it says that claims data is the primary source of information when it comes to targeting abuse, okay? So they will look at things like, what's your volume? What is your percentage of Medicare and Medicaid? Well, for the folks on the phone today, when it comes to home health and hospice, you and I know that's almost all your business, okay? That's it. And I know you don't think about it possibly this way, but the fact is the federal government is your business partner. And when they come in and they conduct an audit, you can lose the whole business if they're not satisfied with what they find. So it's so important that you have an effective compliance program in place. They look at, when they're choosing targets, they look at history of prior investigations, your error rates. Okay, now your error rate, something like that, that's why it's so important. We've seen so many cases in TPE audits and run-of-the-mill ADRs where the client was so busy they didn't even have enough time to turn the information in that needed to be turned in. Therefore, the claim was denied. Or once they got the denial, they didn't have enough time to really appeal the denial. And they thought at the time, well, it's just a single claim or it's two claims. We're not going to lose any sleep over it. We don't have the, it's more costly for us to have to bother with that than it would be to just let it go. Bad idea, because now the government is looking at these denials, not just as the overall error rate, but also we're seeing cases now where they will actually cite the fact. They'll say, we sent out a request for 3 claims, ADRs, and you did not respond, and they were all denied. That is what they use then as a springboard later on to justify suspending a home health agency from its billing privileges. Okay, so little things like that can make a huge difference. Your overpayment history, your appeals history. I thought this is very interesting. This is right out of the Medicare Program Integrity Manual. If you are going to appeal, they check and see how many of these went to the quick and lost, and then they never went any further to the ALJ. So they take all this into account. Now, secondary sources, these are the things that you also may think of. So the primary source, of course, is data. Slicing and dicing the data to identify outliers, okay? Secondary sources, complaints. We've had cases where complaints are filed by the beneficiaries, filed by physicians, filed by competitors. Referrals also coming from agencies. In the old days, it was ZPICs. Now and there's still, we kept ZPIC up here because, just to let you know, there are a couple legacy ZPICs out there that are still doing work as ZPICs, and they're still closing out cases as ZPICs. It takes years to have the full transition over to the new UPIC system, which is no longer really even new. Reports, OIG and GAO both, they just harp on home health and audit. It seems like every year one of those agencies is coming out with some damning report against home health providers or hospice providers, saying that that they're not doing something they're supposed to be doing. And then the next thing you know, within 6 months, now CMS has issued marching orders to the MACs and to the SMRCs and to the UPICs, and you guys are starting to see increases in audits. State licensing boards. This is something that is relatively new. We're starting to see, and we've seen this a lot in Texas. We haven't seen it yet in Louisiana, but we have seen it in Texas, where if there is a False Claims Act settlement or there is another audit that becomes public, okay, against a licensed provider, we have seen the medical board and the nursing board then initiate, as sua sponte, on their own. They've initiated an investigation because they take the position that if improper billings have been submitted for payment, and now you're having to pay it back and possibly pay penalties and fines, well, they think that that's a violation potentially of the Medical Practice Act or the Nursing Practice Act. The professionalism provisions and the provisions in there that say that you can't engage in improper conduct. So we're starting to see the boards kind of going in the wake, if you will, of these government audits and investigations. Okay. Next slide. All right. So when it comes to administrative actions, for the folks on the phone, the ones that you really need to work or need to be most concerned about are audits by UPICs, Unified Program Integrity Contractors. And these guys, they're not law enforcement, but they view themselves as some type of law enforcement. What they're doing, of course, is they identify potential cases for referral to the OIG and to the Department of Justice. And the Program Integrity Manual says that they have to do it. If they identify something that looks like it may constitute fraud or abuse, they have to, under the terms of their contract to CMS, they have to make these referrals. Okay, so it's really important that whenever you get any type of an inquiry by a UPIC, we strongly recommend that, the first thing you do, don't try to handle it completely on your own, all right? And the reason for that is, I know you think you have a good handle on what the requirements are with respect to medical necessity, documentation, coding, billing, and the rest of it, but many times we find that that's not necessarily the case. We do recommend that you get someone in there, a qualified health lawyer, whoever that's going to be, that you feel comfortable with, and have them kind of help you guide it through the process. And I say this because, in my opinion, the way to deal with these, and I'm fixing to ask Lester his ideas on this, but the way we do it here is when our clients, if they call us in the beginning, when they first get the request letter, let's say they're requesting 30, normally if it's going to be a post-payment audit, in order for them to extrapolate, what they've done is, extrapolate damages, what they've done is they pulled what they say is a statistically relevant sample from the universe of claims during the period at issue. And that's normally at least 30 claims, okay? And so if they do that, sometimes they will identify the actual date of service that they're concerned about. Sometimes they won't. Sometimes they'll just say, we want the entire file for this patient from 2016 to 2022. And that makes it really tough, especially as we know with hospice cases, because that can be thousands and thousands and thousands of pages. Anyway, if they do that, what we typically recommend is if we know when the dates of service are, we know exactly what they're looking at, we work up what's known as a claim summary. And essentially it lays out a clinical profile of the patient. It says, here's what's required for coverage and payment. And here in the medical records, and we reference the specific citations, here are where all of those requirements are met. Lester, can you talk some more about this process?
Yeah, the claim summaries are critical. I mean, it's when you just hand over a bunch of records, there are, as you're all aware, there are 10,000 different ways to say that those records are non-compliant with some Medicare or Medicaid regulation. I mean, they just have too many rules out there. So giving them a guidepost, like, a map, roadmap to how the patient's clinical presentation meets coverage requirements and how, and then specifically what portions of it really focuses them in on the areas, presumably, if you're compliant, that are best. And so I think it just sets the tone for their review, when you can flat out state, this is, X, Y, and Z is required, and here's X, here's Y, and here's Z. It's how we win every appeal when we actually do file an appeal, but providing those on the front end really kind of focuses them in on what's important. And trust me, if you don't do that, their imaginations will run wild, and they will, all of a sudden, patients are too heavy or too fat for care. Then next month the patient's too thin. They'll just come up with any reason they can conjure up. But if you keep them focused on the regs and the facts, that's by far your best chance of getting out with an approved claim or minimizing denials.
And especially in cases where they are trying to extrapolate damages by knocking out a potential claim on the front end so that it's not denied, that's going to significantly lower the amount of damages. So that's the other reason why you're doing this before they look at it. Finally, the reason why we like to do it, why Lester and I like to do this, is because we try to make it so that a sixth grader can look at this and know that the requirements are met. We want to make it as difficult as possible for them to deny these claims. And I will say, it's not at all uncommon. If you don't do this level of analysis before you send the paper in, you don't know really if you're missing anything. And it's not at all uncommon for us to say, well, wait a minute, where's the list of all the medications? And, we have to go back and we have to ask the client, obviously they've left something out, or we need a copy of the referral from the doc, or whatever paperwork it is, lab test results, whatever it is that supports the medical necessity, makes the documentation complete, shows that it was properly handled. We want to go on and turn all that in on the front end, because if it's not, and there's no other way really to do a proper review of the documentation for completeness unless you do this type of analysis. Next slide. Now, I don't want to suggest to you that every time you get a letter from the UPIC, you're going to have a False Claims Act case or a criminal investigation, because that's not the case. More often than not, most of the UPIC audits end up being an overpayment matter that you fight if they're wrong. You pay the money back if they're right. But the point though is that you really have to be careful, because when you do get that request for documents from a UPIC, you don't know at that point how your name ended up on the list. Was it because you've got something that there was a patient complaint or a competitive complaint or whatever, or your numbers just askew, and you're doing more of a certain type of patient than any of the other providers in the state? You don't know. So that's why you have to take each one of these UPIC requests very, very seriously on the front end. Next slide. Now, one of the things that, and I'm going to ask Gunnar about this, and the other reason why we're so concerned about these little issues, whether it's a TPE audit or an ADR, and those are different, of course, or if it's a probe sample where the UPIC just wants to look at 10 claims. Well, they're not even typically with a probe sample. They're not looking to extrapolate yet. They think there may be something there, but they don't know. So they just want to look at a handful of claims to see. Then if there is something there, they'll come back later on. But what we're seeing, Gunnar, and I know you've worked on a number of these cases, is they will take the results of these, what a couple of years ago, Lester and I would consider to be inconsequential, an ADR request, and the client decided not to fight it because it wasn't cost effective, or TPEs, and they're bootstrapping a suspension action off of it. Is that what you're seeing, or tell us what's going on out there?
Yeah, it's definitely what I've been seeing with whether your documentation or your certifications. It could be one little thing that's not meeting the Medicare guidance in the manuals that falls in the middle of 200, 300 pages of guidance. It's just one bullet, and that can serve as a grounds for denials of payments and also referrals to UPICs and other administrators to take administrative action, such as suspensions. We've even seen additional document requests from CMS themselves that are almost disguised as a SMRC audit, but in reality, it's from the fraud and abuse department of CMS. So there's a lot of clever ways where the documentation now is serving as the impetus for additional administrative actions, such as suspensions.
That's right.
We're looking into fraud and abuse allegations to the DOJ. So it's,
and if you actually look up in the Federal Register what they meant when they said, this idea that they can suspend your billing privileges for a credible allegation of fraud, one of the things that they mention, of course, is provider audits. So the results of provider audits, the results of data mining, hotline complaints, which could be anonymous, a bunch of different reasons. But with suspensions, of course, there is no administrative appeal for a suspension. You have the right to file a rebuttal, but the fact is that suspensions can be the kiss of death for organizations like home health and hospice agencies, where a significant portion of your monies, if not all of it, is coming from Medicare and Medicaid. So a suspension action is something that we're seeing more of. We aren't seeing those directly imposed. They are almost always the result of, well, they love to cite the fact that you've had 3 separate audits over the last 2 years. Well, they weren't really significant in size or scope, but they still use that as justification then to impose a suspension. Okay. Revocations. Gosh darn, we see this especially on the home health side, not necessarily on the hospice side, but we've had so many cases around the country, lots in Texas, by the way, where they will show up at your listed address, the address you have in the system, and there's nobody there. Now, when do they show up? Well, they have a bad habit of showing up around lunch, okay? So, you know, then they will, based on that, they will issue a revocation of your Medicare number. And, you know, that's very difficult because the revocation rules have changed. A couple of years ago, they changed so that now a revocation, it used to be that they could only revoke you for up to 3 years. Now they can revoke you for up to 10 years. And there are a bunch of different reasons that they can do it. We talked earlier about the fact that we've seen a significant increase in the number of suspensions that are bootstrapped off of payment audits. Same thing with revocations. They can use a pattern of billing errors, okay, as a basis to revoke your Medicare number, okay? So you really have to watch it. And you know, once that Medicare number is revoked, then it's just a matter of time before your Medicaid number is revoked. Same thing on the Medicaid side. If they revoke your Medicaid number, that's a basis for Medicare to do it as well. So, you know, you really got to be careful when it comes to these administrative actions. One final thing about this, it just never ceases to surprise me. One of the reasons that comes up again and again every few years is billing for deceased beneficiaries. Okay, now I've actually seen cases as a prosecutor and on the defense side where the provider was alleged to be billing for services provided to deceased beneficiaries, and in fact, that's what was going on. I mean, they were engaging in out and out fraud. They were, you know, buying Medicare beneficiary information, and they were billing for that services provided to those beneficiaries, and they didn't know that the individual had passed away. So that happens. But more often than not, it's a mistake. We've seen situations where the services were provided to an actual living person, and it went to the billing company or the biller for the organization, and the biller did not put in the proper date of service. Instead, they billed it as of the date that they got around to billing it. And in that 2-month period, the individual had passed away. So, you know, you have to really be careful. And it really shows why, if you're doing your own billing, you need to make sure that the person handling your billing understands the rules and understands the need to be accurate when it comes to billing for these services. Next slide. Okay. 3 years ago is when it was, and in September, they really expanded the ability of Medicare to revoke someone's billing privileges. Okay, the ones in black there, 1 through 12 were the original ones, and then the ones 13 through 21, those are the new bases to revoke somebody's billing privileges. 9 and 12 are in the red because they updated those two. But it's interesting to look at some of the new reasons that they can do it. One of which was, you know, if they were billing from a non-compliant location, okay, so let's say during COVID you decided, well, we don't really want to go downtown, we're going to bill from this other location, and you know that wasn't approved at the time. That was a real problem. But one of the ones that comes up a lot, not with home health and hospice as much as other providers, but if you do have a debt that is referred to Treasury. So let's say that the UPIC comes in, they do a large extrapolated audit. They say that you owe $3 million. Well, nobody has $3 million that they can pay off. Once it goes through the administrative appeals process, if you don't take it to federal court and take it all the way, the fact is that Treasury will start sending you letters to try to collect this information. the mere fact that that debt has now been referred to Treasury, that can be a basis for revoking your Medicare privileges. Okay. Next slide. Denials, that's a little bit different. We're not talking about revoking somebody's privileges. Now we're talking about it's time for you to re-up, and they have decided that they're not going to allow you to re-up. Okay. They also expanded those rules. Looks like a couple of my bullet points got pulled over there, but you know, they're looking at a bunch of different reasons why they no longer have to allow you to renew your participation. So you have to be very careful there as well. Next slide. All right. TPE audits. Gunnar, you want to talk some about TPE audits?
I'd be happy to. So targeted probe and educate, they are a clever means. I mean, they're a useful tool to help providers essentially comply with certain areas of Medicare guidance that they might not already be doing. It sort of gives providers three rounds of review to achieve a quote unquote passing score, otherwise receive a failing score. And after you receive the first round of review back, you're able to get education from CMS and their Medicare Administrative Contractor, or MAC, who will walk you through sort of the areas that need improvement, so that for the next round of review, you are able to get your pass score up, so you can pass. And the ideal is to have a passing score of 100, to be honest, because once you do a TPE in the first round and you get a score of 100, they'll sort of let you go. They have nothing more to educate you on or probe you on. So that's ultimately the goal, is to do as best as you can, but these TPEs also serve as a precursor to numerous other administrative actions that CMS and its various contractors can take.
Such as the suspension and revocation.
Yes, exactly. So if you score terribly on a TPE and they start noticing a trend within your either documentation or billing practices, they'll take note of that, and they're under an obligation, as we discussed, to refer those to UPICs, to SMRCs, to CMS itself, who will then
decide what actions.
Decide what actions are necessary after the TPE. So the TPE can basically be like the first step of discovery, if you think in like a case, their first step of the investigation, lay the groundwork for what other information CMS might want to request from you somewhere down the line.
Now, probably everyone on this phone call that works at a home health agency has already been through a TPE audit. I mean, that's really where the program was initiated. Now we have doctors, we have DME companies, we have all kinds of providers and suppliers that are now being subjected to TPE audits. But hopefully everyone on this call has already been through this process, and you're pretty educated about the downside of what can happen. Next slide. All right, so let's talk a little bit about prepayment review and prepayment review. You know, there's so many different flavors here. I mean, a TPE audit, a lot of times that is on the it doesn't have to be necessarily, but that's on the prepayment side most of the time. And ADR is on the prepayment payment side, or you can be on 100% prepayment audit. The important thing is, and what we recommend with these prepayment audits, you're going to have a very tight schedule that you have to get them all the documentation supporting that particular claim and turn it in. What we like to do, it's the same way that we handle the post-payment audits. We work up a claim summary. So we say, we know you're looking at this claim. Here's the clinical profile of the patient. Here's what's required for coverage and payment. And here's where all those requirements are met. Once again, now's the time to do it. If you find that you got holes in there, you need to go and try to track down missing information. You may have to get an affidavit from the patient or the family or the doctor or whoever it is, so that you can really try to support the claims, because you don't want to stay on prepayment review any longer than necessary. Okay, it's very important that you get off of that, because number one, it's time consuming and costly, but number two, every time that they extend it, it's because your error rate is still too high for them to feel comfortable to take you off of it. And, the longer you stay on it, the more likely it's going to lead to a post-payment audit, the more likely it's going to lead to something more nefarious, such as a suspension or a revocation action. Gunnar, can you walk us through, you do a lot of these home health and hospice audits. Can you kind of walk us through these primary reasons for denial that you've been seeing in the home health side?
Yeah, absolutely. So to start, just walking down the list, auto denials, those are issued when there's wishful thinking and home health agencies just would like to not submit any documentation in hopes that it will go away. That results in auto denial, and as we discussed previously, that raises a lot of alarm bells for CMS and contractors to not just let it go away, but instead continually focus and come back to get those documents that they requested the first time around. Face-to-face encounters, they are required for the home health certification and to provide those services and determining whether they're medically necessary. A lot of the certifications, if they're invalid or they're untimely, they result in an automatic denial for any claims that were made during that certification period. So basically, it's starting off on shaky grounds for that period, and if it starts off shaky, then you're not going to get paid for the rest of the services provided. So you really want to make sure that those face-to-faces are timely and sufficient to meet those requirements. The initial certification, again, sort of goes to the face-to-face, although this is actually starting the beginning of the home health care. And if that is missing any of the necessary information for medical necessity, explaining whatever scores or conditions the patient has, if those aren't properly elaborated on, that will result in a denial as they're not able to determine the medical necessity for home health. And that could carry over to numerous other certifications. If it's sort of mimicking that first certification and that first certification was insufficient and you continue it forward, then the problem is just going to continue forward. The plan of care, a lot of the time, provider will just clone those. They'll just move them from certification period to certification period, and reviewers hate to see that. They hate to see that there's not, your plan of care essentially is a way of showing you're adapting to the patient's needs and what you've noticed during their time on care.
And progress.
Exactly. And progress.
They want to see that this is a living, breathing approach to this patient's care. They don't want to see that on day one, you've decided what you're going to do and that doesn't change no matter what happens.
Exactly. So that really will grind their gears, so to speak. Again, medical necessity problems, that comes down to the need for sufficient documentation showing exactly what services were provided and why. You can't just provide a generic note and it's the same note for an entire month or 2 months of service. It'll raise alarm bells as to what exactly that service is for and where's that service going. Is the patient getting better? From 3 visits a week, is it going down to 2, down to 1? If it's remaining consistent, it starts to look as if these services are not medically necessary or appropriate. And then again, insufficient documentation sort of covers all of them all in one in a way, where if you're insufficient documentation, there'll be medical necessity problems, there'll be plan of care issues. And just to reiterate, the cloning of notes when it comes to home health and hospice records is a serious problem, and it leads to a lot of questions asked by the reviewer and could lead to further requests for documents or just an automatic denial. You really want to make sure that documentation is sufficient, and the best practice is if it's not documented, then it didn't happen. So make sure that you're documenting.
Which is not really true, Gunnar, and I'm glad you said that because that's what CMS always says. But, the fact is, this idea that if it's not documented, it didn't happen, well, that's not necessarily true. It's possible that it's true, but the fact is, just if it's not documented, there may be, if you find something's not documented, if it actually occurred, we encourage you to go out there and get proof that it occurred, whether that's getting a statement from the family or the patient or getting the test results that support it. we're not perfect. We make mistakes when it comes to documentation, but I just don't like this idea that they think that incomplete documentation means that that the services weren't provided. That bothers me.
Bothers me too.
Okay.
It's one of those circumstances of, it's the best.
Next.
They're cynical reviewers.
That's what they're paid to do. I mean, they're paid to look at a cold record, and that cold record tells the story for them. And if there's not something in front of them that supports it, they're trained to deny it. Now, what about on the hospice side?
So on the hospice side, things are very, it's based on the Medicare guidelines. It's, as I was sort of saying a few minutes ago, there's very nitpicky rules, such as when a face-to-face encounter needs to occur, it has to be within 30 days of a benefit period beginning, or 30 days or 30 days before the certification by the provider. They have specific requirements as to who can actually certify a patient as being terminally ill, aka having a prognosis of 6 months or less.
And that's kind of difficult too, isn't it? Because on the hospice side, depending on where you are in the country and who your hospice mech is, for hospice you may have half a dozen or more different LCDs that you have to refer to, and you have to know the rules for in terms of medical necessity in order to determine whether or not they actually meet the criteria to qualify for coverage.
Exactly. And also, it's required. No physician has a crystal ball to see the future and knowing exactly how that patient's disease will progress. And as much as they can refer back to LCDs, at some points, patients just keep getting recertified because ultimately they do still meet those local coverage requirements, but they're not meeting that prognosis of 6 months or less. So I think that also creates some issues in terms of the auditor during a TPE review or any other administrative review. We've also seen a lot of issues with auto denials based on not providing patients with the notice of non-coverage addendum that is required in the election statement. If this isn't provided timely, CMS is able to just deny the entire claim period just based on that simple not providing a document. We've seen that a bunch of times where the form that is submitted is just insufficient and doesn't cover all the grounds. You really want to make sure that if you're providing that notice, you're walking through exactly why certain items aren't covered under the hospice care, why it's not towards the palliative care of that hospice. So you want to be very mindful of just, again, those nitpicky rules that they can use and pull out the manual and just deny without even reviewing your records or without even reviewing the documentation in its entirety.
And I think one thing on both hospice and home health for everyone to keep in mind is assume that there's going to be a reviewer look at the record and assume that they're not going to agree with you on the length of stay or whether or not a new certification period is justified. So when you do have long stay patients and you've got your interdisciplinary team meetings going on or whatever process you use to review those, justify in the record why you think another period is needed. Exactly why. Why haven't they gotten any better after 16 different periods? Why are they still alive 3 years later for a hospice patient? Sometimes there's reasons why, and they're perfectly legitimate, but you just won't see that written in detail, that you discussed it and that everyone still thinks that the patient needs care. I would document that very clearly.
Okay. There are a number of other general reasons. Gunnar went over some very specific reasons for denial that he is seeing right now in cases that he's working on. Some of the other areas, though, that we're going to talk about, and I think we're going to talk about, Lester's going to talk about them in the context of cases. Illegal solicitation cases, kickbacks, disguised kickbacks, gifts to patient, failure to conduct exclusion screening. Guys, that is probably the single most significant reason out there. If, in fact, you haven't been screening like you're supposed to every 30 days, if you are employing someone who has been excluded from participation, that taints everything that person has touched. And if the person who's excluded is on the billing side or on the administrative side, and they're theoretically involved in the basket of services for all your patients, you've got a real problem. So please, if you're not currently screening everyone, you're supposed to be screening every 30 days, your employees, your vendors, and your contractors, please do so. You need to. If you want more information on that, go to exclusionscreening.com, exclusionscreening.com. All right, next slide. I know we're kind of low here on time. Very quickly, with the False Claims Act, we've now talked about the administrative cases we're seeing. On the civil side, almost all the cases are under the False Claims Act. And under the False Claims Act, if you knowingly submit or cause to be submitted a false claim to the government, you can be liable for penalties and damages, essentially, treble damages and significant penalties. Next slide. And these penalties down at the bottom, you can see it's gone up. Most of the people on this phone remember when it was only 5,000 and 10,000. Well, now it's 11.8 and 23.6. Okay, so and knowledge. When I say if you knowingly submit, we're not just talking about actual knowledge. We're also talking about reckless disregard and deliberate ignorance. Finally, something you need to keep in mind with the False Claims Act is it has a very long tail. The statute of limitations is extraordinarily long. It's 6 years. You can bring a case 6 years from the date of the violation, or a maximum of 3 years after the government learns about it, up to a maximum of 10 years. Okay, so that's really a significant period of time. So if you've been doing something wrong for a long time, theoretically, they can go back possibly up to 10 years and try to hit you with violations of treble damages and penalties. Okay, and that's penalties per claim. Next slide. Now, one thing to kind of keep in mind, and this is something that we're going to talk about really, that Lester's going to talk about on the criminal side. One thing to kind of keep in mind is we have seen a significant increase in the number of cases being brought, not necessarily against the agency, although they are still bringing some cases against the agency, but they're really bringing most of the cases now against the individuals that they think are culpable or played some role in these violations. So we're seeing False Claims Act cases being brought against owners, administrators, clinical staff, billing people, office managers. And part of the reason is because even if you're not the person who was providing the services that are being misrepresented and the government says constitute a false claim, under the statute, if you knowingly present or cause to be presented, okay, well, the role that you play as a biller or as a clinical person or as an office manager, that's enough to drag you in for personal liability possibly under the statute. So you got to be careful because the government now is going after individuals under the False Claims Act side, not just the owners of these organizations, but the folks that are working there doing the work. Next slide. Now, one of the tools that they use to do this is they use something called a civil investigative demand. And a civil investigative demand is essentially a subpoena that is issued by the U.S. Attorney's Office, and it allows them they can do one of three things or all three. They can get testimony from you, kind of like a deposition. They can have you turn over all kinds of paper, like a request for production, or they can have you answer questions, like an interrogatory. Now, what's really scary about these civil investigative demands, they can only be issued pursuant to a bona fide civil investigation, okay? But they can take all that information that they receive and they can share it with their counterparts in the U.S. Attorney's Office on the criminal side, okay? And in fact, today, DOJ policy is when one of these False Claims Act cases comes up, they are supposed to be automatically coordinating what they're looking at with their criminal counterparts, okay? So that's how we're seeing, it's like a string, if you will. UPIC does an investigation. They come up with evidence that they think constitutes fraud. They make a referral over to CMS. CMS and the UPIC then present it to the U.S. Attorney's Office. The U.S. Attorney's Office opens a civil False Claims Act investigation. The information is shared then on the criminal side. Next thing you know, you've got a criminal investigation as well. It gets really serious very quickly. So please be careful. At the first side of a CID, we probably have, I don't know, maybe half a dozen CIDs right now that we're working on or just now closing out. at the first sign of a CID, you really need to call your lawyer and make sure that it's a bona fide healthcare lawyer. Okay, I'm not saying that there aren't others that can't do it, but you don't want to. This is not the kind of case, in my opinion, that you want handled by someone that represents you in a medical mal case. Okay, it's a completely different area of the law. This is something that you need people that have done this many times. Okay, so get someone who has worked on CIDs before, because they need to really understand the gravity of a CID and the fact that if it's not handled appropriately, it can actually lead to a criminal prosecution as well. Okay, now, can they force you to answer? We just talked about the fact there's 3 things they can get under a CID. They can get your deposition, they can make you turn over paper, or they can make you answer questions. But a lot of times our client will say, well, how can they do that? Why can't I exercise the Fifth Amendment? Keep my mouth shut because I don't have to incriminate myself. Well, that's true. You don't. But there's case law out there that says that if you choose to exercise the Fifth in response to a CID, that's fine. They can't make you talk, but the judge can take a negative inference by your failure to provide the information requested or to answer their questions. There will be a negative inference that is taken by the court. In other words, they're going to come at you and they're going to probably hit you with a pretty big judgment on the False Claims Act side. And the problem is, you're between a rock and a hard place, because it's not like they're not going to get the information. Okay, there are other tools that they can issue. They can get OIG involved, and OIG can issue one of their subpoenas, which can be issued in a criminal case, and then you have to turn it over. If you don't, all of a sudden, you're going to find yourself in contempt, or you're going to find yourself being subjected to a search warrant. So, these little things. We're seeing these, and there's a case right now that's going on in North Carolina that I've been monitoring, where a doctor supposedly made false statements and improperly modified documentation when she was responding to a UPIC audit. Well, that UPIC auditor, they picked up on this. They made a referral to the U.S. Attorney's Office. Now she has been criminally prosecuted. So, these little audits can spin out of control. You have to be careful. You cannot revise or modify improperly altered documentation. Okay, that doesn't mean that you can't correct wrong documentation, but any changes that you make, you need to make sure that they're always, that you make it very clear to a third party. This is when this amendment was made. Okay, it was by this individual on this date, and its purpose is to correct the record. Here we say that the person weighed 210 pounds when they really weighed 310 pounds. That type of a thing. So be very careful. You should not make changes to a record in any way, electronically or on paper, that is not completely transparent, so that the government can see what were the changes made. And frankly, you shouldn't feel bad about making changes, whether it's correcting a record or adding in additional information that was erroneously left out. CMS actually has provisions that say that you have an obligation to correct a record. Okay, so there's nothing wrong. You shouldn't feel bad about the fact that you're having to make a correction, but it just needs to be transparent as to who made it and when it was made and what the correction was. Lester, do you have anything to add to that part of it?
No, not on that. We'll get into the referral stuff, I guess.
Yep. Okay. Now it's Stark, and that's Lester going to be talking about Stark. Thank God.
So the next couple of sections deal with really laws that deal with how you drum up business. So Stark law and anti-kickback statute, and there's another one we deal with it mainly in this presentation from the anti-kickback statute, but there's also a beneficiary inducement statute, and it all deals with financial incentives to refer patients or order services that are reimbursed by federal health care program. Stark law deals only with certain, it's civil, that's a big major difference in anti-kickback, and it only deals with certain quote designated health services. You can go to the next slide for a list of those. And physician referrals, which can be nurse practitioners as well, but but it's otherwise fairly similar to an Anti-Kickback statute if you're dealing with one of these designated health services, inpatient, outpatient hospital services, lab, PT, OT, ST, radiation therapy. It runs a home health, obviously, is on there. But it deals with, a physician having a financial relationship, either compensation or ownership, with an entity to which they refer designated health services. Go to the next slide. Robert, I think, touched on this issue. This is dealing with an issue Robert talked about earlier, where and you can go to the next one as well. This is the Yates memo, and it deals with how prosecutions have changed over time, to where previously they wouldn't go after just the company and get the easy, I guess, conviction. Now they want to go after the actual wrongdoers or officers in the company who participated in the decisions that led to their investigation. We'll go on to the next one. So basically, everyone involved in the company can be held accountable themselves. Now, and a kickback, unlike Stark, it applies to all services that are reimbursed by federal health care programs, and as well as Medicaid through another amendment. But it's basically, if you solicit, it's anyone who knowingly or willfully solicits, receives, or offers or pays any remuneration in return for referring an individual for services payable by federal or state healthcare program, or purchasing, leasing, or ordering any goods, services, yada, yada, yada. There's, similar to before, you don't have to have actual knowledge of the section or specific intent to violate it, which actually this is a new change where it's just more, it's going to make it easier for them to bring cases. I don't think it's the end of the world, because so many of these other laws didn't require that we had to have actual knowledge of the specific section, but clarifying it here just makes it easier for them to bring an anti-kickback statute violation. So go ahead, the next one. Now, everyone is subject to these laws. These are penalties. Go into the safe harbors. So these laws are really broad. They cover lots of activities and business arrangements that are normal and are commonplace throughout all of healthcare. So they didn't want to really catch those arrangements. So what they did was, under Stark law, they've got exceptions, and under anti-kickback statutes, they've got safe harbors. And with Stark law, if you comply with every provision there, then you won't violate Stark law, basically. Same thing with safe harbors. It's an affirmative defense. It's slightly different than an exception, but what you need to know is that, with the safe harbors, what you want to do is try to comply with as many of the provisions as you possibly can. It's not always possible with anti-kickback statute, and we still allow deals or contracts or whatever to go forward when they don't comply with every element of a particular safe harbor, but we try to get really, really close. And when we do stray from it, we try to maybe do it based on something we've seen approved in, say, an advisory opinion previously. So let's go to the next one. Just trying to get through as much as we can. Safe harbors, the ones that you'll deal with are personal services, management contract safe harbor. Employment safe harbor is probably the most important one, and the small entity investment safe harbor. So go along to the next one. So where does this? So these are modifications. So on the personal services and management contract safe harbor, there's a very similar exception under Stark law, and it as a strict liability kind of statute. It was a little looser than anti-kickback statute, so they've amended it to make it similar to each other. So now you don't have to have your quote aggregate compensation set in advance, but you do have to have your methodology for determining your compensation to be set in advance. That's bringing that more in line with Stark, which was a lot easier. This is one of the main reasons why lots of agreements would not qualify under the safe harbor, because it would be a, say, indeterminate hourly compensation contract, and then immediately you lose safe harbor protection. If that was Stark law, that would mean you just violate Stark right then and there because you didn't comply with the exception perfectly. Here, previously, before we had this amendment, you would allow a contract that had, say, hourly compensation, and that would necessarily not meet the safe harbor, but we would build in other protections to kind of protect those payments. Go to the next slide. We're down to only a few minutes left, really. So this is employment safe harbor. Is pretty simple. It's any payment by an employer to an employee for employment in the provision of covered health services. what you'll see is they will sometimes, you'll notice that there's no say fair market value opinion, fair market value requirement as part of that. But they'll also often go after providers in other ways when they think that someone's paying more than fair market value to, say, to an employee for, say, marketing. What they'll usually do is they'll say that they're not providing the services that they claim to, and they make you fall outside of the safe harbor that way, or they'll hit them with, if Stark law applies, they'll hit them with a Stark law violation, or any other laws. They've got lots of different laws they can come after you with. So I guess I say that to say that, like, just because you fit a safe harbor doesn't mean that you can do anything you want without any kind of questioning. It will characterize all of your agreements differently than you did. So you want to be as squarely within all these safe harbors as you can possibly be at all times. Let's go to one of the cases, and just so we can go over a few cases before we end. Small entity safe harbor, we just skipped over that one, and it's also an important one, but it deals with the ownership interests as opposed to compensation. That's all the reason really I wanted to talk about that one. So let's go to, we'll go ahead with the cases. I was just mentioning that briefly. Oh.
Go back to the home. There you go. There you go. Perfect.
So there was a first case of Northern District of Illinois. One owner of several home health chains maintained relationships with marketers and signed sham contracts with patient marketers on behalf of the company. So, and owner two was alleged to have facilitated kickbacks by having the marketers write checks to himself and other agency employees, and then they would convert those to cash and then pay the marketers. So it was basically money laundering here. It's a pretty simple one. But they also throw in, obviously reviews of charts, because there was an RN who was allegedly performing assessments on patients when she was out of the country. And basically, they would just try to admit as many patients as they possibly could, regardless of medical conditions. Now, I find that they always make that allegation when they come after someone. Almost always, they're going to say that you're admitting people who don't qualify. But what makes me feel good about reading about cases like this is it's not just that. There's actual bribes here. These people were criminals. And so definitely do not just pay kickbacks to people. They will pop you for that plus everything else they can tack on. There was a case in the Southern District of Florida where another marketer and his co-conspirators paid kickbacks to Medicare beneficiaries. So this would be this is a kickback case, but it could also be brought under the beneficiary inducement statute. Anything that causes a beneficiary to come to you, if you give any free things to them, that's a potential kickback or beneficiary inducement. So these people, it shows that they go out and talk to your beneficiaries, and they're going to ask them flat out, why did you end up choosing this place? And they're, in this case, the marketers were coaching them on how to qualify for home health orders from doctors, just tell them exactly what to say. And so you need to watch not just your employees, but all your contractors and especially marketers to make sure that they're not doing these sorts of things, because it's going to be your company going down along with them if they're out there, say, coaching patients to lie to doctors. Let's see, another Illinois case involved a consulting company. This is using an overseas biller, and they just billed $40 million worth of services that just never were rendered. I guess it brought up the EBITDA for the year, and I'm sure everyone was happy, but they weren't paying close enough attention, and you had a ton of money padding their invoices. Let's go to the next one. There's a few hospice cases I think we had. Let's see, the California case dealt with a Downey, California hospice just paying kickbacks to recruiters. Now, this is something that you need to pay attention to. When your clinical staff, your administration, or let's say you're the DOM, but one of your, a lower nurse voices a disagreement with the appropriateness of an admission or whether someone's terminally ill, don't just dismiss that. And when you do overrule those determinations, you need to have a really good justification and the clinical background to be able to do so. That's what this involved. They talked to clinical staff, and clinical staff, of course, said, well, we didn't think those people qualified, but our administrator overruled us. Very, 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 very common line of testimony from disgruntled employees or people that aren't necessarily disgruntled, when the FBI and DOJ is asking you questions about whether or not you thought that this patient that they clearly think wasn't appropriate, whether or not you approved that, your employees are going to kind of shy away from that. They're going to distance themselves from that decision, and all of a sudden they will remember that they told you a dozen times that patient doesn't qualify, and you ignored us, and that'll be the narrative that they spin in court. So, take all of any complaints by employees about appropriateness of care, take them seriously and try to address those concerns. Don't blow people off, or they may end up being a witness against you. And then finally, the last one was a $4.7 million restitution case, 27 months in prison. And this is basically just trying to convince patients with long-term diseases to enroll in hospice. This is, probably just a long stay patient case. And that's the way they're going to spin the narrative when you have someone who's, you said was going to die within 6 months and they live 4 years. You need some really, really good documentation as to why that patient, A, still reasonably is considered terminal, and B, why they're still living so long if they're allegedly terminal. I know it's not easy to always explain, but you need to have a lot of documentation of discussion on those issues and reasonable decisions on moving forward. Sometimes you're just going to have to, discharge a patient. But let's see if we can go on. Maybe we can go on to the next week. I think we're out of time pretty badly, but I didn't want to hold everyone on too much. But let's see. So this is kind of a summary looking back. Since '92, most of the organizational offenders that were criminally prosecuted and subsequently sentenced by federal courts, most of them have been domestic, most of them have been private, most of them have been small, which is most of you. And usually there's not a good, they may have a compliance program or a policy that says that you're into compliance, but they don't have an actual compliance program that they actually implement. And so you can see the evidence of that in the fact that out of all these 5,000 organizations that have been prosecuted, I guarantee at least half of them had a policy somewhere in their policies that dealt with compliance in some way, but only 11 of them actually qualified for a sentencing reduction. That's because only 11 of their plans were adequate. You really can't just have one policy that says we're going to comply with all Medicare and Medicaid regs, and we're going to report to our supervisors any instances of non-compliance that we witness. That's not enough. You really need an actual program that's actually implemented and monitored, and tries to. What I tell people is when you've had a denial or you've had an audit flag something, make damn sure that that's the last thing that you're going to have happen in the future. So fix problems as you find them every single time. And follow up on your staffers. Make sure that you don't have, say, if there's a bad physician who just will not sign their certifications on time or won't write enough content in the narratives, you got to get rid of them. I've had clients have $10 million+ overpayments affirmed simply because of the doctors and the clinicians they were hiring just would not do the job they were hired to do, which is document their work. So I guarantee you, no matter how much they liked the doctors that were involved in the big case I just mentioned, they don't like them so much that they would like to lose $10 million over there, just to have a agreeable doctor around. So sometimes it can be hard to force a doctor to do what they're supposed to do, but or a nurse or whoever, but you have to do it. You just have to. You can be found criminally liable for their lack of attention. You can be civilly. You can lose the entire business, and everyone loses their job. Go on to the next one. So again, it's just a summary of a lot of things that we've talked about earlier: illegal solicitation or referrals, paying, that's gifts, kickbacks, anything like that given to people who refer to you, including patients. Failure to properly document medical necessity, identity theft, things like that. Failure to conduct exclusion screening. These are the easiest. It's easy to prevent employing someone who's excluded. So I guarantee you, everyone who's ever had a big, massive overpayment for that has really kicked themselves in the butt harder than they've ever done so, because it's really a silly thing to lose, your business over. But there's really not much we can do about it when that happens. Let's go to the next one. Obviously, filing claims for dead people is bad. Don't file claims for services when you're out of country. But always retain counsel in any of these investigations. Like Robert said, sometimes you've got a civil investigation, it's civil, but there's a criminal one ongoing right on the side. And anything you say can be used, it will be used against you. They will, like I said earlier, they will characterize all of your policies, procedures, your practices in the worst possible light when they've decided to come after you. So if there's a red flag and you popped up on their radar, the best thing you can do is try to alleviate those concerns as best you can. And unfortunately, it's not something you can do yourself very easily. So you do need a lawyer to do that, to talk for you. So it's not you speaking to them. It's frankly, it's critical. You just never know. All these laws overlap, and they all have, not every one of them, but lots of them have criminal and civil penalties, and they can take those cases, the same case, same facts, either way they want to go. They can take it criminal, they can take it civil, and both are bad, obviously. But the last thing you want to do is turn something civil into a criminal investigation, because then fighting for your freedom, that's obviously a lot more important than money. And most of this isn't your money. Not everyone on this call I know is an owner of a home health. You just work for one, right? So don't put yourself on the line for your employer, and employers don't let your employees stick around forever. You're not enforcing, say, some documentation requirement. You can lose your business or your freedom because you didn't do anything about it. So it's a constant practice, compliance is, and it's something that never ends. But every time you receive some kind of investigation or, God forbid, a denial, you need to take care of that problem. I think that's it really from me. We're way late.
Okay. Yeah. All right. Well, we did have a lot of slides. We don't usually have this many, but there was a lot of information that we had to go over. So we do appreciate the opportunity to work with the Home Care Association of Louisiana. Dr. Aber, do you have any closing remarks?
Yes, I do. I just want to let you know how much we appreciate your good work, and certainly the credibility of Lyles Parker in the work that you've done for people around the country. This is the first of a series of monthly offerings that we'll be doing together throughout 2023. So look for more information on that in the coming months, and we'll be back together in February. Thanks so much to the team at Lyles Parker. Thank you, Robert.
Thank you.
See y'all next month. Thank you, everyone.
Hey guys, I'm staying on just in case y'all are